I'm Ed Alexander, attorney with Alexander Abramson, and this video is about making an offer. It's part of our Guide to Buying a Business video series. So when you've gone through the process, you've done your preliminary investigation, you feel comfortable with the price, you're going to go ahead and make an offer in writing to the seller. When making an offer, there's two options. You can provide a letter of intent, or you can provide a contract. Now, oftentimes a letter of intent is a good way to go. There are some pluses and minuses to a letter of intent. The plus is that you're not going to spend a ton of time preparing a letter of intent. And if you're making an offer that you're not sure that the seller is going to accept, a letter of intent can be an easy way to get the discussion going without spending a lot of money up front. If you do that, the seller can basically say, hey, you're not even in the ballpark, or then they can counter relatively easily. The downside to a letter of intent is the letter of intent is supposed to be non-binding. I say supposed to be because I've read many letters of intent that did not have language stating they were non-binding and eventually formed a contract. But if it has that language that says that it's a non-binding letter of intent, then it is, as I say, non-binding. The seller is not bound to it. You're not bound to it. So if another offer comes along and the seller finds that offer more palatable, then you could be out of your deal. So that's the downside associated with it. I also say that sellers look at a letter of intent with, I think, being less serious than making an offer through a contract. Okay. So the next is to make an offer through a contract. Now, again, something we've been talking about throughout this video series and really important is that buying a business is very much different than buying a piece of real estate, right? Especially a residence. And so in the residential world, here in Florida, we make offers via contract. So we complete a contract and send it to the seller. And so in that case, they use form contracts. The FAR is what it's called down here, has different types of contracts that are used. The problem with the form contract in a business sense is that it is not tailored to the business that you're buying. Businesses come in all sorts of different flavors and forms. So as a result of it, it's important to have that contract reflect the seller's promises, any open issues, the key aspects of that entire transaction. And oftentimes, down here we have the Florida Business Brokers Association, and they will want to use their standard contract. So when we do that contract, if we do use the standard contract, we typically put an addendum on it to reflect what the specific deal terms are for the business that you're buying. But if not, if we go with a custom contract, then we will prepare a contract for your deal. Now, it's important to remember, we're not preparing this contract out of whole cloth, right? We're using our internal forms to prepare these contracts, and not doing so would frankly be malpractice because these forms have been developed over a period of time. But it's really important that whatever contract you use, that contract is tailored towards the business that you are actually buying. Thank you for watching.